This all starts back on September 6th of 2018 when Botham Jean was shot and killed in his own apartment by Dallas police officer Amber Guyger, who claimed that she mistook him as someone in her apartment. The shooting left the community shocked and outraged. She and others, still others seem confused about what the appropriate charge should be in the death of Botham Jean. And was it murder or manslaughter? And if you recall, there was a lot of controversy about this manslaughter charge, and there wasn't much said about it. As more details were released, it became clear to me, based on the law and the reported facts, that the appropriate charge was murder and not manslaughter, and I said so from the very beginning. I was not in office, I was a private citizen, but I was a candidate for this office. I made this statement on the record, which is important, on the record, publicly numerous times during interviews with local media in 2018 and in 2019. Here are just a few of the places my comment on murder being the appropriate charge over manslaughter was mentioned. Inside Texas Politics, November 2018, the Dallas Morning News, November 19th, 2018, the Dallas Observer, November 21st, 2018, WFAA and NBC5 News and other media outlets. My comments also appeared in the national news, and here's a copy of what I said to the social media. And if you want to go to my Facebook page, it's dated September 12th of 2018. And what I attempted to do was to explain to the community what the elements of the offense from a legal standpoint are for murder and for manslaughter, but I went beyond that and explained all the possible defenses that may be brought up in the case based on only what I knew from news reports. I didn't have any special knowledge, so we have a copy of this for you so you can see that. So anyway, we posted that. Now let's go to January 9th of 2019. Judge Tammy Kemp, and here's what's important. No one requested a gag order. Judge Kemp decided to issue a gag order on her own, and she did it. And she made findings, she claims, regarding publicity and issued restrictions on speech, which are commonly known as the gag order. In order to do so consistent with the United States and Texas constitutions, a judge must hold a hearing, which was not done in this case. Moreover, as stated in an amicus brief, and it's important because these are not my words, they're not the words of anyone representing me. These are the words of a foundation interested and focused on free speech. And it said, the gag order is an impermissible prior restraint that cannot constitutionally reach the speech of an elected official fulfilling his duty to keep the public informed. Texas and federal law are inherently skeptical of any such restriction on speech and demand specific and extraordinary findings before an order is issued. The order here, issued without any evidentiary hearing and based primarily on unsubstantiated, and this is a quote, extensive media coverage, unquote, does not pass the strict test imposed by the Texas or federal constitutions. I am an elected official obliged to keep the citizens of Dallas County informed about the prosecutions and court proceedings handled by this office. It would fundamentally impede the exchange of information vital to keeping Dallas County citizens informed on the public administration of justice if basic statements regarding the murder trial of a defendant are in violation of the law or court gag order. Basically, I was stripped of my rights as an elected official, or attempted to be, and as a person protected by the First Amendment and the Texas Constitution on the flimsiest rationale, if you can even call it a rationale. Instead, I was subjected to a biased, vendetta-like attack on me personally and professionally by Judge Kemp, bearing no resemblance to proper legal proceedings. Thankfully, the law prevailed, and the contempt of court charge filed against me by Judge Kemp was in fact dismissed for lack of merit. I can finally say that I've been vindicated. Although I could have spoken out before now, I decided it would be prudent and appropriate to let this issue work its way through the court system. Now that it has, I want to explain what happened to cause that statement of mine to be publicized. So on September 16th of 2019, my public information officer received an email from Fox 4 reporter Allison Harris requesting an interview about PTSD and mental health following the death of one of our assistant district attorneys, and we have that email right there. In particular, Ms. Harris asked about the initiatives we were taking to address mental health as it related to the recent increase in crime in Dallas. I have written down here at the end of the interview, but I don't know if it was actually at the end, but middle, end, while we were doing cutaways perhaps. I'll be honest with you, if you had asked me the Monday that this trial started, that Ms. Harris even asked me these questions that were so innocuous and inane to me, I probably couldn't have even remembered that these questions were asked. But in any event, she did ask me questions about the Amber Guyger trial. Specifically, she asked me whether I felt comfortable with the murder charge instead of a manslaughter charge. I simply stated what I had publicly said dozens of times, and that is, this is more appropriately a murder case based on facts as presented, and I've studied what we have, which I had, and I feel comfortable that we're going forward on it, but I don't have any idea how it will end up. And that was it. The reality of it is, and we couldn't get the outtakes, there were many, many more questions that Ms. Harris asked me that I did not answer. But this was nothing new, nothing remarkable. And in fact, what was the indictment for murder? What was my team doing, prosecuting a murder case? So for me to say that that's the appropriate charge, how can that possibly violate any reasonable restraint on speech? Anyway, her original story on mental health aired a few days later, which was Thursday. Then we get to Sunday night. I never saw it. I didn't look at it. Ms. Harris's story ran, and it had my comments. Once again, the same comments I made back in September of 2018, before there was even an indictment. One would certainly think if I'd made those statements in September of 2018 and they'd been publicized as much, that the potential jury pool, if they had seen it, certainly would have brought that up, and certainly had it biased them or prejudiced them in any way, they would have stated so. And we certainly asked a number of appropriate questions about that. Both sides did. So anyway, the comment was innocuous and a comment I'd made before. But the bottom line was, and I'll go into this, even though the gag order is unconstitutional and void as a practical matter, I didn't violate it. On September 23rd, Monday morning, as the trial was set to begin, the defense, and I think appropriately so, I don't blame them for raising this issue before the judge. I think it's their job and their responsibility in representing Ms. Guyger. But they raised a question. They didn't even say that I had violated the gag order. If you go back and look at it, they said that I possibly violated the gag order. So they appropriately said I participated in an on-camera interview with Fox 4. The problem was everything went to Sunday night, as though I did this the night before to have some bearing on the outcome of the trial, when in fact this interview was several days before, the week before. And any statements made by anybody in court, made by Judge Kemp, made by the Dallas Morning News, or anybody else that I did this the night before is just false. Judge Kemp immediately reacted in a negative manner, as we've all seen, even before knowing what was on the videotape or attempting to determine the facts. Her initial reaction was visceral and dramatic. It was obvious, and, in my opinion, an attempt to make a blatant biased judgment against me. As a former judge myself, I found that behavior unprofessional and prejudiced, and a prejudiced attempt to disparage me without any type of due process. She repeatedly and erroneously stated to members in the courtroom and those watching on live television, as I understand it, I didn't watch it, that I gave an on-camera interview with Fox 4 on Saturday night or Sunday night, which, once again, is not true. She continued to openly display her unprofessional behavior and obvious bias towards me. The problem here is I was a Dallas County judge for 21 years, and I find it inexcusable for one of my peers or colleagues to make assumptions that lead to illegal action before knowing all of the facts. To me, it speaks of their judgment and character. For the criminal district attorney of Dallas County, or any attorney, to be slapped with a contempt of court proceeding with little to no facts, as in this, is unconscionable. And if it can happen to me, it can happen to you, it can happen to a witness, it can happen to a police officer, it could happen to an attorney, it can happen to anyone, any city leader, any civic leader. And you could find yourself, like I did, facing 180 days in jail. And, most importantly, and fortunately, when I was given this show cause order to come down to the court and explain why I should not be held in contempt of court, that stopped me from being the district attorney of Dallas County for a considerable number of days, because I had to stop my work and I had to find a lawyer. I had to find somebody who could handle this, and I did. But the fact of the matter is I also had to expend probably something that the average person wouldn't have, and that's $20,000 to get a lawyer started. As you all know, it's been reported Dallas County has approved the $30,000 payment for my legal fees, and so the bottom line is the citizens of Dallas County will be out of $30,000 for this exercise that we just went through in the last couple of months. So, moreover, I think it's personally wrong to target an individual without evidence of actual wrongdoing or providing due process under the law. It's just flat unconstitutional. The purpose of a true gag order, which I've never seen one upheld on appeal, by the way, is to provide a defendant with a fair and impartial jury while weighing that against an individual's First Amendment rights. Gag orders are not meant to preclude an elected official, especially the criminal district attorney of Dallas County or any other county anywhere in this country, from executing the duties of this office or their office and commitment to the citizens of their community. And it's time for that to change. So we're going to have a change in policy that I want to let you all know. It benefits, I think, everyone involved, and it benefits you all. In the past, just like this gag order, I knew about it, and I wasn't too concerned about it, to be honest with you. I never expected that myself or anyone would have to go through what I did. But from this day forward, if any judge on his or her own issues a gag order, there's about a 99.9% chance that we're going to do everything in our legal power to get it taken down. And if that means we have to go to the Court of Appeals or to the Supreme Court of Texas or to the Court of Criminal Appeals to do so, then we'll do so. I've also ordered my staff that they're not to ask for a gag order unless they come to me first and get my approval. To be quite honest, I can't imagine any circumstances where one would be appropriate. If one is asked for by the other side, they're to report that to me, and we'll take a look at it and see where we are. I've never seen a gag order appealed that was upheld by a court of appeals. Never. And if you think about it, and you think about this trial, the particular trial, the Amber Guyger trial, they got 12 fair and impartial jurors. And it didn't have anything to do with me, despite all of the publicity that this case got. And so it begs the question, is there really even a need for a gag order if you could get 12 fair and impartial jurors like you did in this case with the publicity that this case got? I was always of the opinion that this case would be tried in Dallas County because I've picked too many juries as a judge with too many high-profile cases. And I've never seen it be a problem that you can get 12 people who either haven't heard about it, which seems unusual, but it happens, or they haven't made up their minds, and they can be fair and impartial jurors. Just because they've heard about it doesn't mean they can't be fair and impartial. So I want to go on a little bit more and some of the other things that happened in this to kind of help explain why the motion to recuse was filed and what happened there. So obviously, if you were looking at it, I think reasonably from my perspective, considering all that had gone on, and after the trial, that I would be given a show cause order, I thought it in my best interest that Judge Kemp not sit on this contempt hearing. And so we filed a motion to recuse. And then we start another chapter of conduct by Judge Kemp. So the law is quite clear. We have rules regarding motions to recuse, and they're contained in Rules 18A and Rule 18B of the Texas Rules of Civil Procedure. So if you'll look for it, that's where it is. Rule 18A is the process for either recusal or disqualification of judges, and Rule 18B are the reasons a judge could be disqualified or recused. And I want to point you to something very important in Rule 18A, subsection F as in Frank. Duties of the respondent judge, semicolon, failure to comply. 1, responding to the motion. This is very important. Regardless of whether the motion complies with this rule, which is previously set forth, the respondent judge, within 3 business days after the motion is filed, must either, colon, A, sign and file with the clerk an order of recusal or disqualification, which this is not, or B, sign and file with the clerk an order referring a motion to the presiding judge. What did Judge Kemp do? She issued a void and unsubstantiated motion to disqualify me from litigating whether she, under the circumstances I found myself, is the appropriate person to decide whether or not I violated an unsubstantiated and illegal, unconstitutional gag order. She didn't have the authority to do that, and the case cited was of no value. What else did she do? She sent a little message to the presiding judge to strike my pleadings. If the judge had done that, where would that leave me? Back in front of Judge Kemp. It was obvious, and we used that as evidence, that further evidence that it was inappropriate for Judge Kemp to preside over the contempt proceeding. You know the outcome of that. Without hesitation, the judge granted it, and she was removed from further involvement in this proceeding. Then after that, it was an issue of I had to recuse myself. Obviously, I don't know if you know this, but the law requires that the district attorney of the county where a contempt action is prosecute the contempt action. Well, I can't prosecute myself. So it was appropriate, and I immediately signed an order of recusal. The judge who heard the recusal was not allowed to hear the actual contempt matter, so another judge was eventually appointed, and eventually Patrick Wilson from Ellis County became the prosecutor on the case. He looked at it, came to the same conclusion everybody else did. And when I say everybody else, I was confronted during this period of time by people who are not lawyers in all sectors of this community in this town asking me, what in the world is it that this judge thinks that you did or thought that you did that violated anything? And Patrick Wilson came to the same conclusion. But most importantly was the show cause order itself. The show cause order didn't even allege any violation of the gag order, which was another reason that we presented this to Judge Brotherton, that there's no way that justice can be served with this judge hearing this issue with these myriad of things. So the bottom line is 4 pieces of paper were signed by Judge Kemp. The gag order itself, which is void because it violates the First Amendment and the Texas Constitution on free speech. The show cause order, which didn't allege that did anything to violate her unconstitutional gag order. And then the disqualification and the suggestion to strike my pleadings, which of course would have put me right back, obviously, where she wanted me to be, which is in front of her. This behavior to me is disturbing. It's concerning. I don't know what the genesis of it is, but once again, I want you all to know and to understand that there was never any attempt by me to influence this case. I thought I was doing an interview about mental health, post-traumatic stress disorder, and these initiatives and working within the district attorney's office. At the time I did that interview, one of my assistants had taken his own life. And that's what that was about. Did I think anything about the questions that were asked? No. Should I have? Maybe. I trusted that that's what the story would be about. I know I don't have any control over what reporters do and what they report. But I just want to let you all know and let the public know that at no time did anybody in this office try to derail that trial, try to influence that trial. We had respect for the presumption of innocence, but we also felt confident going forward that we had the correct charge. Did we know how it was going to end? No. If you go back and look at what I wrote in September of 2018, and if you remember the issues that were raised in the case and the instructions that the judge gave, you'll find it eerily correct how I was as to what the possible issues and defenses would be in that case. How was I able to foresee that? Because I've practiced law for 37 years and I spent 21 years as a state district judge. Was I right? Did I know I was right? No. Was it necessary to be right? No, it wasn't. I was simply just expressing what I felt the facts back in September based on news reports supported. And later on, obviously, I had gone over the case multiple times with my staff and reviewed the case and what I felt was appropriate. And I thought, and I still to this day think that I conducted myself appropriately, with dignity, with respect for her presumption of innocence, and we conducted ourselves that way throughout this trial and throughout this unfortunately extended contempt proceeding. I think I've done the same thing. So anyway, that's the change in policy. No time in the past, and you all, some of you like LP, you've been around a long time, you've seen these gag orders go out and everybody just kind of lays back. That's not going to happen anymore. Okay, I promise you that. I don't want anybody to have to go through what I went through. It's not right, and it's not fair to you all, and it's not fair to a person who would get try to be held in contempt and put in jail for 180 days under these circumstances. So anyway, if you have a few questions, I'll take them.
Judge, it sounds like you're angry.
I'm not angry. No, I'm disappointed, but I'm not angry. I think that this is all obviously, I mean, you've been around a long time. You've never seen this happen to anybody. I mean, really? So no, I'm not angry. I'm just disappointed. But also I want to explain everything. As I said, you all have, I'm going to get to you. You all have hit bits and pieces, and you're not able to because you have a limited amount of time and space and, you know, however they give you to do your stories. But I thought it necessary to go through all of this and explain this so you can see it, pick and choose what you want, however you want to. But I'm just giving it to you, and that's why I have the documents for you.